So, yes, you were under arrest. There's a warrant for your arrest. And the police, the officers are going to get with you on this. And 45 CR 1228. Are you, you're Inland Falk? All right, Mr. Falk, you were charged here in 25 CR 1228 with the second degree felony of aggravated assault with a deadly weapon. Do you understand? Which carries with it up to 20 years in prison. Because this was handed up back in September by the grand jury. And this goes on to allege, though, that you were convicted of robbery 2 times in the 252nd District Court on the same day, May 24th, 2002, long ago. After those 2 convictions were final, it is alleged in the indictment that you committed the offense of illegal possession of a controlled substance, a 3rd-degree felony, and you were subsequently convicted of that on February 21st, 2019, also in the 252nd. So if all of this is true, you are looking at habitual felon status. No less than 25 years, no more than 99 years confinement in prison or life in prison is what you're facing. You understand? This was the guy was facing yesterday in yesterday's trial, who got 55 years in prison.
The mood changes almost instantly. What starts like a routine bond hearing suddenly becomes far more serious as a judge lays out a criminal history that completely changes the stakes. You can almost feel the courtroom realizing this is no ordinary case anymore.
You are under arrest at this moment. Do you understand? So, yes, you are under arrest. There's a warrant for your arrest. And the police, the officers are going to get with you on this, and they will be able to talk to you about it. But this has popped up, and you got to answer for it. We're gonna make a copy for you so you can have a copy of it. But your bond is revoked.
Imagine expecting to walk into court for a hearing, then hearing the words, "You are under arrest." That's the kind of moment that instantly changes everything. Every plan you had disappears in a matter of seconds.
Due to this warrant. And what was his bond before? What was your bond on this?
I think it was
20,000 for habitual felon and committing aggravated assault.
Judge, I believe the issue here is the case was filed and dismissed, and I believe he bonded out on that first filing. And when it was dismissed, there was no warrant, and he didn't bond out on the new indictment. So I believe that's what's happening today.
That's correct. He has no bond on this new indictment.
Yeah.
So he's just make bond.
So
I don't find this bond enough at $25,000 anyway. Who said the bond? But you are a habitual felon, sir, and these are 2 prior violent crime convictions and then a serious illegal possession of a controlled substance. And now this is aggravated assault by threatening to use a deadly weapon, namely a vehicle.
This wasn't just about paperwork. From the judge's perspective, public safety outweighed every technical argument. Once a defendant's record came into focus, the discussion shifted from procedure to risk.
So your bond is increased to $100,000. There's a way to avoid all of this, is to not to commit crimes. And if you post a bond, you will be at home confinement. You must have a GPS device. You cannot leave the home except to and from work, the most direct route possible, to and from hospital care, to and from acquisition of food, and those are the other purposes. And that's the way it is. Do you have an attorney?
Also,
Are you unable to hire somebody?
at the moment,
Fill out an indigent form, and an attorney will be appointed to represent you.
Notice how the judge doesn't simply increase the bond. Every condition is designed to reduce the chance of another incident. Whether people agree or disagree, the message is unmistakable. Accountability comes first.
We'll appoint somebody today from the public defender.
so, sir,
You're taken into custody. That's the rulings of the court.
all right, for you, sir, can I say something?
No, sir.
My boys, man, they were freaking my boys in the back. My boys,
Sir, your bond is too low. Sir, you are a danger to the community. Your bond is far too low under the circumstances that we have. Plus, there's a warrant for your arrest, and it's not a debate, sir. Follow the rules of the court. Thank you.
That may be the strongest moment in the hearing. The judge isn't debating anymore. He's making a decision based on the defendant's history and the seriousness of the allegations. Sometimes a courtroom reaches a point where the discussion is simply over.
We'll just get her to fill out the indigent form for the jail.
Next is Jaquan Lazard. Next is,
As to the assault and battery, how do you plead?
Your Honor, I'm sorry to interrupt the court. It was brought to my attention that I had put a little bit of a different offer in writing to Mr. Carter. I don't know if I did that inadvertently, but I will honor that. And that would mean that would change it to him pleading to still the added count of an attempt R&O with dismissal of the balance of charges.
Well, he didn't know that. You didn't know that? I'm asking him. You can't tell me what he knows. I'm talking to him. You didn't know that?
Yeah, I did.
So why you ain't say that? And when I said if that's your understanding of the offer, why you say, Judge, that's not what they told me?
No.
You don't think you got to protect yourself out here?
Yeah.
You got to do better. You got to get a belt and you got to protect yourself. You understand that?
Definitely.
Okay, so we're dismissing the assault and battery?
That is correct, Your Honor. I apologize.
No worries. As to the attempted resisting obstructing officer, how do you plead?
Yes.
And that's because you believe you're guilty of that?
Yes.
Are you sure?
Yeah.
Factual basis.
Mr. Robinson, on or about December 15th of 2025, were you in the city of Lansing,
Yeah.
Ingham County?
Yeah.
More specifically, 3933 Phoenix Drive?
Yeah.
And at that time, did you come in contact with police officers as they were investigating a call that they received?
Yes, ma'am. Yes.
And at that time, were you in a altercation with a Mr. Johnson?
Yes.
And the officers gave you commands to stop and you did not immediately stop?
Yes.
And they actually ended up having to say that command more than one time, isn't that correct?
Yes.
And you refused to do it at first, correct?
Yes.
I have nothing further.
People are satisfied.
The court is satisfied with the factual basis. I'll accept your plea. I appear to be freely, voluntarily, and intelligently made. This matter is scheduled for sentencing March 6th at 9 o'clock in the morning, okay? We're gonna go downstairs and check in with probation before you leave here today, and they'll get you scheduled for a pre-sentence interview. You have any questions at this time?
No.
Any additional matters for the record, Johnson?
No, Your Honor, thank you.
Thank you.
Courtroom can change someone's future in just a few minutes. One ruling can mean freedom, another can mean custody, stricter conditions, or years behind bars. It's a reminder that every decision made before walking into court can have lasting consequences.